All right, so we are still on the preparation for the upcoming exams. Please remember that this is not a full class. It is not a lesson. It is about, let me say, admonition. It is about recapitulation. It is all about revision. We are trying to revise a little bit what you have learned, the do's and the don'ts. I had wanted to meet you earlier, all of you, on this, but by the time you were writing your papers, myself too, I was writing papers. So far, I've written 40 papers from January up to now. It's not easy. So I just finished. So I said to myself that it is quite okay for me to share the burden with you. So at least this is the little that I could do to assist some of you. So with all due respect, these are some of the questions that you can meet in land law exams. Land law exams. Land law exams. Listen to me carefully. These are some of the questions that you could meet in land law exams. Question like explain the four main ways, or explain the main ways of acquisition of allodial title and how it could be lost. Explain the four main ways of acquisition of allodial title and how it could be lost. Don't forget, I explained that one with you yesterday. When you are coming to the ways that it could be acquired, then you let us get to know that we have the modern view and then we have the traditional view, the old view. The modern one, you see, when we talk about allodial title, we are talking from section 2 of the Land Act. Anytime you talk about allodial title, your attention has to be driven to section 2. I think we did all this yesterday. So we examine it accordingly, and then we look at how it could be acquired and how it could be lost. So if you didn't get time to watch the videos, I think the recordings, you have made them available. You can go there and watch them. You could also get this one: with the support of authorities, carefully examine the concept of land. With the support of authorities, carefully examine the concept of land. Remember that if you are talking about the concept of land, we discussed it yesterday. With authorities, cases and statute, or even constitution. So you carefully examine the concept of land. And then yesterday when I was teaching, I was going through the land with you. I even said that sometimes you can get a question which will say, what is land? Law is so interesting to understand that someone who sometimes doesn't know the answer but knows how to answer law questions are sometimes far better than a person who knows the answer but doesn't know how to go by the structure of answering law questions. So it means that how to approach law questions are very important. They are equally important as the answer. I have encountered so many instances of which I don't know the answer, but because I know how to approach the questions, I find my way out moving around it. So please get to know how it is done. That will be, don't worry, if first semester has been a mess up, don't worry. From second semester going, we are going to do a lot of corrections. So please, don't worry. At least you should get experience a bit that you suffered somewhere. So that is how it is. So put it at the back of your mind. When they say, what is land? Don't just go straight and say, define land. No. We don't do that in law. So the essay type, I explained to you that when you are starting with essay type, You can give some history, brief history. You can give some article. You can use some article. You can use constitutional provisions. You can use statutory provisions. You can use a case, and then you'll be bringing it down, You have to get to an introduction. From introduction, you come to body. From the body, you go to conclusion. Now, introduction is telling us what you are coming to discuss. Introduction tells us what you are coming to discuss. The body tells us what you are discussing. And then the conclusion tells us what you discussed. So we don't use the conclusion to introduce new points. And you shouldn't write an essay type questions of which you don't conclude. If you don't conclude, it's something else. Conclude. And then the introduction, you let us get to know what you are coming to discuss. The concept of land has undergone a lot of scholastic views, or has attracted a lot of scholastic attention. However, there has not been an exhaustive and conclusive definition so far as land is concerned. The definition that has been given so far all describes land, but do not specifically defines it or tells us what land is. It ranges from biblical context, statutory context, and what other learned judges have also said, or other learned authors have also said about it. So it ranges from what learned authors have said, statutory, what statute has also said, what else? What Bible has also said. Then you come down in this essay. I'm going to discuss the concept of land, giving reference to the biblical view, statutory view, textbook view. And I shall also, or on top of that, I'll talk about characteristics of land and end with ownerness of land. And then you are going. That is essay type. So that is the intro. Intro is telling us what you are come to talk about. Then the body, you make sure. So within the intro, you introduce something that for these things shall be discussed seriatim. They shall be discussed seriatim. So that we get to know how you are going to discuss them. You are not going to mix them up, because you said you're going to analyze the concept of land, starting with biblical view, followed by statute. So you dare not go to the body and then say, to begin with, a land, the concept land under statute is no. He didn't say it. He didn't name statute first. He said biblical view. So when you're writing essays, you should be very careful. Like you go to court and then you want to raise your points and then build your points at court. You list them. You raise the points and then you tell the judges that I wish to start from the bottom, from the last to the top, or from the top to the down, and then all of them, so that all of them could will be able to follow you accordingly. You don't just mix them up. You don't just mix things up. Orderliness is very important so far as the law is concerned. So you put your things together and then you come up with your thoughts. So that is how it is. With the support of authorities, carefully examine the concept of land. That one, be very careful about it. So explain the main ways of acquisition, or 4 main ways of acquiring a allodial title and how it could be lost. That one also is very important. So that is how it is. Then the new Land Act 1036, which is 2020, has made several changes in the existing laws on land. Explain probably 5 changes with the aid of authorities. Explain 5 changes with the aid of authorities. That is what we are going to begin with today. And the changes that the Land Act has done so far as Ghana land matters or land related issues are concerned. In fact, this particular question is the question that dropped in last year Makola entrance exams. The one that they went, of which other group are yet to come and write. I mean the current one, those who are in level 100 over there. That is a question that dropped in their entrance exams. That is a question that dropped in their entrance exams. So please, some of us, we are in the system, we have been following, we have been monitoring a lot of things. When the thing comes, we get to know how and where it is leading to. So that is a question that dropped in the entrance exam. So learn it once and for all. In fact, other books tried their best. Some give about 10, some try almost 12 and so. But we have, to me, the research I've done, I have 25 changes. 25 changes that it has actually introduced. The Land Act has actually introduced. But for the exam's sake, we are focusing on exams. We are not just the rest. We will learn them later. I think we have gotten time to study a bit, but the purpose of this discussion or this meeting is to get ourselves prepared for the exams. So today, that is what we are going to do, and then we end with renewal of leases, and then the problem-based question on the gift. We try and see if we couldn't meet Godwin tomorrow. Then at least you have gotten almost enough to answer 3 questions, because yesterday alone I taught you three questions. We went through 3 questions. So even if you want to depend on yesterday's own, you have 3 questions, and then today I'm adding 2 to it so that it will be 5. And then the problem base, which is the gift, I don't know though, but because we couldn't start early today, that's why I want to skip it. All right, so quickly, the Land Act, some of the changes that it has made. Some of the changes that the Land Act has made. Some of the changes that the Land Act has made. Some of the changes that the Land Act has made. That is what we are looking at now. All right. After this, I will also drop something on the platform. Yeah, I will not be able to project it because I'm working on it. It's a research I'm doing. I'm working on it, and then I'll make it a full document, but I'm not done with it. All right. So number 1 is about spouses, restriction on transfer of land by spouses. On spouses. So what we are trying to say is that a situation whereby, could someone read section 47 for us? Section 47 of Act 1036, section 47. Section 47.
All right. Section 47.
Yes,
please. It says restriction on transfer of land by spouse.
Very good. So
except
you shouldn't wait. So you shouldn't forget that section 47. Please, the question says the new Land Act 1036 2020 has made several changes to the existing laws on land. Explain. In this case, explain 7 changes with the aid of authorities. So the statute would help you. The statute will help you. So section 46, the title is, you can move on.
So section 46 or 47? It's 47.
Okay, 47, but okay, anyway, it starts from 46 though, but you see, 46 is about conveyance to persons jointly. I hope you are getting it.
Yeah.
Hello?
Yeah, hello. Oh, hello.
Can you hear me? Hello?
Yes, it's possible.
Yeah, why is my line breaking?
Perhaps it's the network, but I can hear you clearly.
Oh, okay. If you can hear me clearly, then I think I'm good to go. So what I'm saying is that the 46 talks about conveyance to persons jointly or to person making
Yes.
transfer. I hope you're getting it.
Yes.
Good. And then section 47 talks about restrictions on transfer of land by spouse. So at least you can see section 47.
Okay.
Section 47. Yes.
Okay.
So
So section
47.
47.
Yes. Yeah. Let's
Restrictions on transfer of land by spouse,
good.
except as provided in subsections 3 and 4 of section 38, in the
Then you
absence of
pause.
a written
Wait.
agreement.
Wait. Then we pause. The question is that except as provided in subsection 3 and subsection 4 of section 38. Then we pause. We go to section 38, subsection 3 and 4. I hope you are getting it.
Yes.
We are going to understand it and then we come and put it here. So let us go there. Section
Okay,
38, subsection 3 and 4.
Section 38, subsection 3. It says, in a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed
during the marriage. Mm-hmm.
the spouses shall be deemed to be parties to the conveyance, unless a contrary intention is expressed in the conveyance.
Very good. So even here that we are reading is also a change that has been introduced. So one of the easiest question is this one. One of the easiest. Except that the authorities are plenty. You go to section here, you go to section here. So number one is restriction on transfer of land by spouses. The act acknowledges that in those days, when partners, or let me say when spouses wants to sell their land, or let me say possibly to let me say the married couples when they are living, sometimes you see that the man, when it becomes too hot, or if the man wants to cheat on the woman or something, the man will go behind the woman and go and sell the land. The man will go behind the woman and sell the land. Yes, women can sometimes do that, but it's normally the men who does that or who do that. So the issue is that the Land Act, it restricts transfer of land by spouses. So if the asset was being acquired under marriage, then you cannot transfer it unilaterally. So that is how it is. Unless there is a prior written consent of the other partner. So you can't just transfer it anyhow. You can't just transfer it anyhow. So let us go back to the 47, read a bit, and then we move on, because that is the concept over there. Section 47, restriction on transfer of land by spouses. So you can say that the Land Act under Section 47 has restricted on transfer of land by spouses. You have established a point. Then you use your English, your grammar to add up. Please, yesterday I was telling those who joined that it is not by force to get it in Baba Dito Dito, Chiwempo, the section 47. So sometimes when I see some people learning at live, I just laugh. Section 47, except as provided in subsection 3 and subsection 4 of section 30, then they come and write to see that it has stick. The provision has stick. No. You don't need a provision Dito before you can answer a question. No. What does the provision say? Understand it, use your words. This entire provision, which is almost 10 lines, you can use almost 2 lines to finish it. The provision under section 47 all sums up to restriction on transfer of land by spouses. So you can use the title. It said that the Land Act has restricted or has put restriction on transfer of land by spouses. Full stop. Then the rest will be the things you have come to use to back up. That in previous years, when in previous years, one of the challenges that was encountered was that partners could, one way or the other, move behind their spouses and then sell their land or their property. However, the Land Act has made a provision that an asset that is being acquired under marriage can never be transferred to another person without a prior written consent. Prior written, you underline it, prior written consent given by the other spouse. So that is how it is. You make it very clear, very succinct. So they should. It is not oral. Please, law is law. Then you come back and place emphasis that the emphasis is on prior written consent. Then you underline it. Prior written consent. It is prior written consent because oral consent is not going to be tolerated before the law court. Or you see, around the same thing, but you are getting more issues, more like a lot of things to write. So you see that it means that the court will not entertain oral evidences, oral consent. The court will not entertain that. The court will only accept written consent. And this written consent is not supposed to be after the transfer. It's supposed to be prior, before the transaction took place. Before the transaction took place. Before the transaction took place. Again, the Land Act also has made another change, which is Section 38, subsection 3. You see that we went to Section 47. Oh, don't forget. I hope you remember what you were reading, Mr. Edu.
Yes, sir.
And then Section 47. It was Section 47 that we were reading. And then Section 47 help us to get to know that we should come to Section 38, subsection 3. Do you remember?
Yes.
Now, Section 38, subsection 3 has also given us another point. Don't forget. Oh, it's nice. This question, it is nice, Papa. Now I've gotten Section 47. Within the context of Section 47, I've gotten another changes, which is Section 38, subsection 3. It says that if two partners are married, or let me say couples, all assets or all properties or all land that were acquired, land in this regard, I don't mean just land in this regard, even building is part, don't forget. So all land that is acquired under marriage, whether the woman contributed or the woman did not contribute, there is presumption of joint conveyance of land to spouses. Presumption. The court presumed that there was a joint acquisition. Joint acquisition. So you can say presumption of joint acquisition or presumption of joint ownership. The court presumes that once you are married, that is Section 38, subsection 3, the one you read, in a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, that is jointly acquired during the marriage. There's a presumption that once you were married or once you acquired the land when you are married, then it belongs to the two of you. So presumption of joint ownership, Section 38, subsection 3. Don't forget. Don't forget. Don't go far. Don't go far. Section 38, subsection 4. Let us look at section 47. Mr. Edu, read the section 47 again. I'm giving you tricks. We are, forgive me, I told you that we are here not specifically to learn again. No, we are here to get to know how to get maximum marks from the exams. For the learning, we have done them. But this class or this meeting is specifically for the exams. So we have to make it shortcut. Section 47.
Section 47. It says, except as provided in subsections 3 and 4 of section 38.
So wait. Now we went to section 38, subsection 3. Is that not the case?
Yes.
Now, section 47 says that in subsection 4, right?
Yes.
So let's go to subsection 4. Probably we get another changes so that we get 3. Section 47 alone has helped us to get 3. So section 47 made mention of section 38, subsection 3, section 38, subsection 4. So let us go to section 38, subsection 4 again and read it.
Yeah, subsection 4 of section 38. It says,
good. That is the appropriate way of stating the statute. Subsection 4 of section 38. That is how we say it. Let's go.
Okay, thank you. Okay, it says, where contrary to subsection 3, a conveyance is made to only one spouse, that spouse shall be presumed to be holding the land or interest in the land in trust for the spouses, unless a contrary intention is expressed in the conveyance.
You see, so it's presumption of trust. Presumption of trust. Where contrary to subsection 3, a conveyance is made to only one spouse. Mr. Aubrey, are you married?
Yes, please.
Very good. And then a conveyance is made to only one spouse. I have sold a land to you. That spouse, you, Mr. Aubrey, that spouse, you, Mr. Aubrey, shall be presumed to be holding the land or interest in the land in trust for the spouses, in trust even for your wife. I don't know whether you are getting it.
Yes.
When someone gives you land, there is a presumption of trust. Why is there a presumption of trust? Because it belongs to the two of you. If it belongs to the two of you and your name, you use your name to do the documents, do you think that one alone will save you? So some men will say that, hey, I won't use my wife's name to do the document. Even if you use your wife's name to do the document for the land, she can't go and sell it. She can't claim that it is mine because it belongs to the two of you. Whether it is in your name or it is in her name, it belongs to the two of you. But remember, it is not traditional marriage. It is marriage by ordinance. Court does not know traditional marriage. It knows marriage by ordinance. Though it is a rebuttable presumption in the sense that sometimes the court comes down a bit, try to be a little bit lenient. However, the best is marriage by ordinance. So now we have gotten 3. Number 1 is presumption of trust. Presumption of trust. Number 2 is presumption of joint ownership or presumption of joint conveyance of land to spouses. Number 3, restriction on transfer of land by spouses. So spouses alone has given us 3. Spouses. Restriction on transfer of land by spouses. Presumption of joint conveyance of land to spouses. Presumption of trust, spouses. That one also is there. So I think that is how it is. I hope it's clear now.
Yes, sir.
Good. Okay. Shall we visit section 72? Section 72. Section 70, subsection 2. Yes, please.
Okay, so subsection 2, section 70. It says a conveyance shall be expressed in clear terms and in plain language, and in particular the words lease, conveyance to, interest, land, or, and at may be used in preference to the words demise, grants and conveys unto, estates, piece
Peace,
or parcel of
of
land,
land.
all or all and singular,
And situate,
and
lying,
situate, lying, and
being at.
being at.
Good. So simplicity, what is the act trying to say? Section 72. The Land Act has introduced preference for the use of clear terms when conveyancing. When conveyancing. Please, the conveyancing, don't be confused about conveyance. When you say conveyance, someone say, conveyance, what does conveyancing mean? They have been saying conveyancing. I don't know whether you understand conveyancing.
So is it synonymous to transfer?
Yes, you can take it like that. So when you go to section 281, so all this one, you can add this one to it. Then you see that section 281 is the interpretation to the Land Act, section 281. So if you want any word that you don't understand in the act, go to section 281. 281. There's a dictionary there. You could just call interpretation. Conveyance includes a document in writing by which an interest in land is transferred. So simplicity, in our normal words, we are saying that you are selling land. I don't know whether you are getting it. In normal words, it is about you are selling land. So in the conveyance includes a document in writing by which an interest in land is transferred. An oral grant under customary law that is duly recorded in accordance with this act. A lease disclaimer, release, and any other assurance of property or of an interest in property by an instrument except a will. Simplicity. Conveyance is like you are giving out your land to someone. You are conveying it. And we are saying that the Land Act says that during conveyancing, use clear in plain language or clear in plain terms. You are done. You are done. There is no need for you to be mentioning lease. Use some of it. Oh, you can use some of them as an example. That example of these words are lease, conveys to interest. Then you put etc. You are trying to be smart too. You can't mention all. Then you say etc. But don't use words like demise, grants, etc. You're good to go. Then you are adding up on top of that. Then you say that this will prevent any ambiguity from happening. Sometimes it becomes very difficult for the court to do interpretation when the words are ambiguous and vague, you're good to go. The rest are your grammar. You have your section 70, subsection 2. You are gone. So now let us close our eyes and try to see whether we remember something small. We have looked at section 47. We have looked at section 38, subsection 3, section 38, subsection 4, section 70, subsection 2. Don't forget. That is what we have done so far. That is what we have done so far. That is what we have done so far. So please understand it once and for all. Understand it once and for all. Understand it once and for all. Yes, I hope it is well understood. Please let me hear from feedback. Hello, please let me hear from you.
Sir, please, you said the section 281. That's where they have interpretation.
Yes, please. Section 281.
You said something that there are interpretations of difficult
words. Yeah, the difficult words within the act. That's what I mean. Within the act.
Okay.
Yes, within the act. So when you're reading the land act and you see awareness at this word here, what does it mean? Go there. Section 281. It is like a dictionary. In fact, every act has interpretation.
So does it mean that subsection 2 of section 70? Hey, that one, I don't know. I don't remember what you said, but I think it's about the conveyance.
And when you are conveying land, you should use clear and plain language. That is the.
So can you chip in the section 2 subsection 81 into the clear language because of the interpretation of those difficult words?
I don't know the context you want to put it.
Like we have section 72 saying talking about the conveyancing. During conveyancing, we should use clear language, plain words, and not difficult words to avoid ambiguity. And I'm asking if you can bring in this section 281 about the interpretation of difficult words attached to the use of clear language.
Okay, forgive me. The question you have asked is English. Add something small to it so that I'll take it to be with you.
May say section 70.
No, I understand you, but let me help you. Then you have to end your question on this note. How should we put it in the question? How should we use it to support the session?
Okay.
Subsection 2. I hope you are getting it. That is number 1. Now let me also ask you that how do you want to? It is because you are the one who is seeing that you are the one who is having that eye. So sorry, can you hear me?
Yeah.
Hello.
You go off and come back. So I think it's okay.
Yeah, someone was calling. How do you want to use section 281 to support section 70 subsection 2? Yes, I'm asking.
I don't think it will be possible because they said we should.
It's individual. If you don't see it, If you don't see it to be relevant, you ignore.
Yeah, because they say we should use plain language. So if you are to go for the interpretation of the word, then it means you've already used difficult words.
You are not getting it. You are not getting it. Please. You see, the act says that when you are conveyancing land, the plain words doesn't mean this act too. It means that the document you are preparing to transfer land. And I told you that conveyance, I had wanted you to, the reason why I went to section 281 myself specifically, I had wanted you to understand conveyancing, because I've been saying conveyancing, you are beginners in the law. So some of you are saying, what does the conveyancing mean? What does the conveyancing mean? You and I, who are staying at Kaswa and then Accra, we know I'm going to buy land, I'm going to sell my land. Is that not the case? That is what we are very familiar with. Yes, that's what we are very familiar with. My father is selling his land. My father went to buy land. But the legal term is conveyancing. So I just went to the section 281 to let you know that when you talk about conveyancing, this is what it means. This is what conveyancing means. So that when I say conveyance, for the purpose of our discussion, I'm not going to say sell, buy again, because now we are growing up a little bit in the law. So I'm not going to say buy, sell. No, I'm going to use conveyancing. So for you to understand me and be in my shoe, I have to go to section 281 and let you understand what the conveyancing means. And then after that, establish the fact that I didn't go to section 281 specifically that there's a point there. No. Section 281 is like a dictionary to a land act. So any word, so I'm just giving you a hint that any word that you don't understand within the land act, go to section 281 and go and read, go and search for the word there. It is like a dictionary. Every act has an interpretation aspect. I think the Criminal Offences Act, its interpretation is at the beginning. I think its interpretation is at the beginning, section 1. But at the Land Act, its interpretation is at 281. So you should get to know all this. So when you're reading it, for you to appreciate the act very well, if you don't understand any word, go to the interpretation aspect. That is what I want to say. But for the purpose of,
Thank you.
But our discussion, we are using only section 70, section 70, subsection 2. That is where the changes we want to talk about is. Okay. All right. So we are. Mrs. I think I have answered you well, respectfully.
Yes, please. It's clear. I'm okay. Thank you.
Okay. All right. So now we can move on. I think how many have we gotten so far?
According to my listing, I think it's 4 now.
Okay.
Restrictions on the partners for them. Yes, 1 is restriction on the partners, and then 2 we talked about.
Don't use partners.
Spouse.
If it is a lesson time, I would have taken it like that. But because we are preparing for exams, if you use partners, myself and you could be partners. Law does not see partners to be people who are in relationship or people who are married. So you use spouses. I hope you are getting it. So presumption of trust. And then the conveyance, and one cannot convey the land without the consent of the other. And then, so that is how it is. Now, the next one is the establishment of customary land secretariat. Establishment of customary land secretariat. The Land Act has also done us much good for establishing customary land secretariat. Customary land secretariat. So now when you go to some regional office, we have land secretariat. All of them are there. So section 14. Mr. Aubrey, I think you can read it for section 14. Section 14. Section 14.
Please, can you hear me?
Yes, please.
Okay. So section 14. Section 14, say customary land secretariat.
Good.
Subsection 1. It
So,
says,
so don't even waste your time. Like I said, now we want shortcut too, because we are going to write exams. We want shortcut. Section 14 talks about the establishment of customary landlord secretariat. Is that not the case?
yes.
So that's all, we are done. So section 14 talks about the establishment of customary land secretariats. So that is it. In those days, we were not having customary land secretariat. What's the function of the customary land secretariat? So the function of it, at least you get to what they do. Probably they are
that they were to keep record of the lands.
Very good. Record customary interest and rights. So you just use your word, two functions you understand, you put them there. Recording interest and rights in land. Don't forget, yesterday we started with the interest and rights. Section 81 and then section 82. Is it 181 or 81? Registrable interest and then the registrable rights. We learned it yesterday. Yes. Section 81 is registrable interest, and then section 82 is registrable rights. So they are there to keep records of interest and rights in land. You can put it there, simple. If they keep records, then they provide relevant records. They are there to provide relevant records on land. I hope you are getting it. And then the customary land secretariat, they are also there to prepare periodic accounts of all revenues that has been received. Periodic account of all revenues. Get 3. Add the 3 to your explanation. You are gone. Section 14 has established or has introduced what is called customary land secretariat, which is responsible for the keeping of records on interest and right in land. They are also there to prepare periodic account of all revenues that have been received. Again, they are there to provide relevant records on land. You're good to go. You are good to go. I think it is okay now.
Yes, sir.
Okay.
Is it possible? Very sorry, I need to take us back, just one step back. I want to clarify with section 47. Is it enough if we just talk about the first part of section 47? Because I realized we didn't mention subsection A, B, C, and D
of section 47.
Of section 40. Yes, please.
Do you know why I don't want to be going by? I didn't want to, even the section 14 that you mentioned, I didn't want to go into it. Sometimes you have to play smart. Sometimes you have to play smart. Are you going to keep the A, B, C, D, E, all of them in your mind? I told you that you need to understand what the session is about. I don't know whether you are getting it.
Okay.
Understand what the session is about. That is why when you mention the title of session 14, I said, let's move on. What is it about? What is it about?
Okay.
It is about the establishment of customary law secretariat or customary land secretariat. The section 47. What is it about? Restriction on transfer of land by spouse. So you can read the A, the B, the C, the D, the E. You can read it and understand.
Okay.
However, all of them boils down to restriction on transfer of land by spouse.
And transfer of land. Okay.
I hope you are getting the context.
Okay.
Let's go to
Yes,
section.
please.
Let's go to section 73. Remember, we went to section 70. So because we went to section 70, let me add section 73. We went to section 70. So let me add section 73. So that when we go to section 70, section 70, section 73.
Okay. So
Don't forget.
section 73.
Wait, let me do a little bit recap. That's how I teach. You know me. I keep on repeating myself.
Yes.
So far, we have done section 47, restriction on transfer of land by conveyance or by spouse. Then we have also looked at section 38. We have looked at section 38, subsection 3. We shouldn't forget section 38, subsection 3. And then we said that section 38, subsection 3, specifically talk about presumption of joint conveyance of land to spouses. When you give it to Mr. Aubrey, you have given it to Mrs. Aubrey. So presumption of joint conveyance of land to spouses. That is section 38, subsection 3. So 2 now. 1 is restriction on transfer of land by spouses, section 47. Section 38, subsection 3, presumption of joint conveyance of land to spouses. Section 38, subsection 4, presumption of trust. If the land is being given to Mr. Aubrey cannot say that it belongs to him alone. If Mr. Aubrey uses his name to do the land document, it doesn't mean that it belongs to him. We are married, so it belongs to all of us. So that one also is presumption of trust. The court presumes that Mr. Aubrey, your name is on the document because the wife says you should put it there. The wife agreed that put it there, you are the man. It does not necessarily mean that it belongs to you, of which you can just wake up and go and give it to your younger brother. Go and give it to your mother. That is why some people become so smart enough to use their mother's name on their documents. Because if it is your name, it belongs to all of you. And if it is your sibling's name, then it belongs to your sibling. So please, that's how it is. So from there, we also move to section 70, subsection 2, section 70, subsection 2, which talks about establishment of customary land secretariat. We shouldn't forget. Now, I might end on section 73 because at least I've given you a bit. I told you that I've done research and I got 25 changes. 25 changes. 25 changes. So I'm adding one more to it, and I think it is enough. It is enough for you. We have section 73. Section 73. Yes.
Okay, so that's the third point.
No, it's not the third point, please. You have done a lot. So section 73.
We have will be the fifth point.
You say?
The section 73 will be the fifth point.
Good. So
Okay.
section 73. Electronic conveyancing. Electronic conveyancing. Don't forget.
Transfer by electronic conveyancing.
Electronic conveyancing. You can use electronic approach or method to do your conveyancing.
Okay. So
it could be done through electronic.
Okay, so subsection 1 It says,
Oh,
where in this act?
don't worry. Don't go there, cry. So section
Oh,
73 also brings in electronic conveyancing. In those days, it was traditional. You bring alcohol, we sit down. You bring snap, we sit down. We do this. No, this time around, you can do it online. And it is still appropriate. Again, a lot. It also places obligation on the family heads to make account to the families. Because you are Bushapani, you think you can chop our money and then you go your way. A Bushapani, you become touchy. No one holds you accountable. No. You hold you accountable. So that is how it is. That is how it is. The Land Act has section 13. So we went to section 14. So 13 also is there. Section 14, 13. Section 13 is what?
management of stool or skin or family land.
Good. So the
Section
section
13.
13 also, yes. Section 13 also has introduced a way of managing stool lands, skin lands, and family land. It says that you have to be accountable to your members. You have to be transparent. So because you are holding the land in trust for the people. So it is your fiduciary duty. It is your fiduciary duty to be accountable to your subordinates. It is your fiduciary duty to be accountable to your subjects. It places an obligation on the family head. It places an obligation on the stool head, on the skin head, to be accountable to his members or to his family, to the subjects, because he is holding the land in trust. Because you are a family head does not mean it belongs to you. No. Please, if you want to know the functions of customary land secretariats, it is at section 15, please. Section 15. Provide relevant records on land. So you can go there, section 15. Section 15. But now I'm talking about management of stool or skin or family land, which is section 13. Section 13 places an obligation on family head. If you're a head, in those times, no one can force you to share. That thing belongs to all of us. You want to use it to take care of only your children for them to go to school, and all of us will be sitting there just like that. So the Land Act has now placed an obligation. Even land gas. I don't want to talk about it now. Even land gas. Now the Land Act has made their activities a crime. People normally don't mention that. But it is part of my research. Land gas. Yes, land gas. Now it has become a crime if you are doing that. So those who are those who have been employing the land gas, it is against the law. It is against the law. I think section 43. Let us go there and try and see whether we can. Section 43. So you see that I'm giving you more. I said it is okay, but I'm still giving you more. Section 43.
Section 43. Voidable conveyance.
Okay.
That's voidable conveyance.
Okay, move on.
It says, subsection 1, a conveyance of land or an interest in land which is made with intent to defraud is voidable at the instance of a person who is prejudiced by the conveyance. Subsection
Okay.
2. Subsection 1 does not apply to the law of insolvency and does not extend to a conveyance of an interest in land where the transferee took the interest
Oh,
in good faith.
I'm coming on my section. I'm coming. My section is that's not the same conveyance in valuable transfer. I'm coming. It looks like you're reading section 43, right?
Yes, please.
Oh, land gas. Oh, okay. Disposition of no consideration in land. Except when pension is valuable. Okay. Anyway, whilst we are moving on, when I get it, I will let you know. So the Land Act also has criminalized the activities of land gas. The activities of land gas. Activities of land gas. So if you're a land guard, now it is an offense under the Land Act. It is an offense to the person who employed the land guard has committed a crime. And then the land guard himself also has also committed a crime. So don't forget this. Again, section, where should I put it? Usufructuary. Usufructuary interest is section 5. You can go to section 5. Section 5 and section 3 of the Land Act. Please, all these ones, when I'm about stopping, then it comes. When I'm about stopping, then it comes.
Sir,
So
please,
that you can go through and pick the easy ones. Section 5 and section 3. Yes, please, we're talking to the land gas. I'm
yes,
searching
I
for
wanted
the
okay. So is the section 43 still included? The voidable conveyance.
No, hold on with the
Is it
section
one of the
43.
points?
Hold on with the section 43. I'm searching for the land gas. I will let you know. But yes, please. Let's go to section 5 and section 5 and then section 3.
The land guard is at section 12.
It's section 12. God bless you. Section 12. Thank you. Section 12. I like that. My people are following. Yes, land gas. Hey, thumbs up. If you happen to be here, I would have given you are you Mrs.? If you're Mrs.
A warm hug.
No, if she is Mrs. If she is Mrs., then comment reserves. I like that. Now, land guards. Section 12, subsection. Let's go to subsection 2. Section 12, subsection 2.
Okay, subsection 2, section 12. A person who uses or through another person uses force, violence, or intimidation to prevent or obstruct a lawful owner of land from developing the land commits an offense and is liable on summary conviction to a term of imprisonment of not less than 10 years and not more than 15.
Good. So the land gas, they are there. And then subsection 1, paragraph C, or subsection 1C. Personally, on top of the two. On top of the two. So C, section 1, section 12, subsection 1C. On top of the two. Just one step on top of the C, on top of the two. On top of where you just read, just one step on top.
On top, C. That prevents a developer from developing the land.
Personally, yes.
Is that it?
Personally.
Okay, personally or through another person unlawfully uses force, or violence to prevent a person who has an interest in land from having access to the land, or drives away that person with an interest in land from the land commits an offense,
Very
then
good.
is liable on summary conviction to a term of imprisonment of not less than 5 years or more than 15 years,
So
or
how are you going,
to both.
how are you going to use it? This is how you are going to state it. The Land Act has also criminalized the activities of langars. Not only the langars, but those who also employ the langars. I hope you are getting it.
Yes, sir.
That is the principle there. That is the principle. That is the principle there. So langars. Now let us go back to our session with. God bless you, the one who gave us the session. Now let us go back to our section 5 and then section 3. This is section 3. Yes, section 3. Now the principle here is that what does section 3 say?
Section 3. Section 3. Customary law freehold.
Section 5.
Section 5. Usufructuary interest.
Now in the Old Testament, when I say the Old Testament, I mean before the Land Act. These two things were treated the same. I hope you are getting it. They were treated the same. But the introduction of the Land Act has differentiated the customary law freehold from usufructuary interest. Do you remember the question the lecturer gave you? One of your assignments. He told you to differentiate between customary law freehold and usufructuary interest. Do you remember?
Yes.
That is the.
I do. I remember.
Very good.
I think it was one of the mid-semester exams.
The mid-semester exam. Good. That is the reason. The reason is that it has been a big issue in the past before the introduction of the Land Act. They used to treat customary law freehold and usufructuary interest the same until the promulgation of the Land Act. I think we have had enough time to talk a bit. Where did I send you to? Section 14. I think another one also has come. Oh, I should leave you. Section 14. It's okay. It's okay. Oh,
I think it's okay. The points are enough for
you said?
for Saturday, so later we shall continue.
Okay.
We have
So
enough points to write on Saturday.
yes. So I think that's all for the Land Act. Please remember that build your introduction. Before you proceed, state it in the introduction. Before the introduction of the Land Act 2020 at 1036, then you do hereinafter shall be called Land Act or Act 1036. It means that from here going, you won't quote the entire thing. Land Act 2020 at 1036. It is too lengthy. I don't know you, but for me, it becomes lengthy for me. When I'm writing according to Land Act 2020 at 1030, it's too plenty. According to Act 1036, according to the Land Act, according to the Land Act, I won't put anything on it. Land Act, or according to Act 1036, I want shortcuts. So you stated in introduction. Before the introduction of the Land Act, there were a lot of controversies, and there were a lot of, let me say, how should I put it? There were a lot of laws that were governing land. You can mention some of these laws. You can mention two of them, and then you proceed with what you are trying to do. When you mention two of them, you are trying to let the examiner get to know that there were some issues, like there were some other enactment that were governing land. So before one could buy land, a person has to be abreast with all this enactment before the person will be able to. This called for the introduction of the Land Act, which has been able to harmonize, consolidate, and to bring together all these individual or separate enactments into one document called the Land Act 2020-1036. This Land Act specifically is there to revise, harmonize. You're going to look at the purpose. The purpose of the Land Act is at page 14. I don't know the particular Land Act you are using, but when you pick any act, it has a purpose. So you go to the leaflet before you come to the arrangement, like the table of content. Is it that the 1036 Act of the Parliament of the Republic of Ghana, entitled Land Act 2020, an act is to revise, harmonize, and consolidate the laws on land to ensure sustainable land administration. I have told you, law is not babao. Don't chew it. You can pick 2 words, 3 words, or 3, like 1 line, and you chip it in what you are coming to write. Until the promulgation of the Land Act, there were several enactments that were governing Land Act, that were governing land matters or land-related issues in Ghana. Some of these enactments are Land Development, which is Protection of Purchases Act 1960, Act 2. So you can say Act 2. You're good to go. Act. Some of these acts were Act 2. You can also say the lengthy something, the name, but Act 2 will suffice. Again, we're having Farmlands Protection Act 1962, Act 107. So you can talk about Act 107. You can talk about Land Registry Act 1962, Act 122. So you can say Act 122. We were having Administration of Lands Act 1962, Act 123. So you can say Act 123. We were having State Lands Act 1962, or Act 125. You can say Act 125. Section 11 of the Survey Act 1962, Act 127. So you can say Act 127. Lands Miscellaneous Provisions Act 1963, Act 161. You can say Act 161. Public Conveyancing Act 1965, Act 302. You can say Act 302. All these laws were repealed. They were revised, harmonized, and consolidated into one document, into one act called the Land Act. Then it's worth saying that the Land Act has done us much good than harm. This is the call for the assessment of the changes that the Land Act has done so far as land-related matters in Ghana are concerned. Following this conspectus or following this synopsis, my essay stands to discuss. Then you pick the question. The question says that the new Land Act 2020 has made several changes to the existing laws on land. Explain the changes. Following this conspectus or following this synopsis, this essay or this bulletin stands to discuss some of the changes that the Land Act has made on the existing laws on land. Starting with this, presumption on this, or this and that. If you can't list them, no problem. I'm hereby, I hereby, this essay hereby stands to discuss the various changes that the Land Act has made on the existing laws, taking into account authorities. That's all. You move on. Then you go to begin with, the Land Act has done this, the Land Act has done this, and then you move on. I think we are done. Thank you for your time. Quickly, let me brush through the renewal of leases, which will take us maximum of, I think, 15 minutes, and then we close. Renewal of leases, which will take us maximum of 15 minutes. So let me save this recording for your per user. All right. Thank you.